Hey everyone, Harry here to talk about an interesting divided opinion in the DC circuit in which the conservative four members of the court are trying to get the Supreme Court to take the case. It's quite obvious. Okay. This grows out of the 1-6 investigation. It's the Twitter case. You may remember Jack Smith subpoenaed Twitter for some of the tweets by Trump and got a number of them, a couple dozen. Now, he subpoenaed Twitter directly, which was a gambit here. They were also held in theory by the National Archives, but had the archives received the subpoena, it would have informed Trump. And they didn't want to inform Trump or anyone else in the criminal investigation. That was part of their rationale. They didn't want anyone obstructing the investigation. So they do Twitter directly, which obviates any responsibility to let Trump or others know. Twitter resisted. It said we have a First Amendment right not to produce it. It presented itself basically as a free speech media company. The court rejected it under the U.S. versus Nixon, Richard Nixon, way back when, the tapes precedent saying that whatever privilege Twitter had would need to yield to the criminal investigative need that Jack Smith had demonstrated. And at that point, the Court of Appeals affirmed on that basis. But then Twitter moved for rehearing en banc, basically stating its same First Amendment defenses. So they state their First Amendment defenses, and the four Republicans of the 11 in the D.C. Circuit, so they got outvoted for rehearing en banc. There is no rehearing en banc, but it's definitely a kind of a cert bait when these four decide to write a statement. It's styled that way, as I'll explain in a moment, and it's something designed to catch the attention, especially of the Trump appointees on the Supreme Court. So what Judge Rao, the most, I would say, aggressive of the three Trump appointees, but joined by the other two and then by Henderson, said is, look, there may be good arguments that Twitter has on the First Amendment side of things where they've lost. I'm not writing about that now. I'm writing about what we did by approving the Jack Smith gambit of going to Twitter directly, because as a result, that prevented Trump from because he didn't know about it, from being able to raise executive privilege claims. And he should have been able to. Normally in cases like this, a president or former president is able to, and it disserved the law, short circuit of the law. They're saying that they went with this approach, but without notifying Trump, because he wasn't able to make his executive power claim if he had executive, whatever he would have done based on executive power. And there's a whole paean to executive power and separation of powers, and why even apart from Trump's individual interests, there's a constitutional interest to be vindicated here, and that the panel ran roughshod over, etc. So 7 of 11 say no rehearing en banc, and these four don't exactly say we should have rehearing en banc. As I say, this is actually styled as a statement by that Rao writes for the four of them, but it's basically saying we messed up. The court overall messed up because it didn't give the opportunity to really consider the rich and important executive power issues. Now, it's a funny thing. You do something like that, you obviously want the Supreme Court to grant cert. It's not clear that the question that they're interested in is presented, however, by the record. So it might be more a way of saying, think about this for the future, look for a vehicle where you can bring it up. But if the court grants the, can always choose what questions it presents, but there has to be justiciable questions, and Twitter is the party here, and didn't raise the executive power arguments. So it's dubious. You could frame them as jurisdictional, which a court can always bring up, but it's dubious that the Supreme Court will be able to do it. And Supreme Court has its hands more than full with Trump matters and, doesn't want more of them. But so if nothing else, this is a kind of a flag thrown down for the future. But it is just always of interest when the bloc, and they are a bloc of conservatives, especially the Trump 3 DC Circuit appointees, speak with one voice and try to, obviously there's nowhere to go now but the Supreme Court, but they want the Supreme Court to be aware of this and think that the subpoena to Twitter really short-circuited improperly, maybe unlawfully. That would be, a question to consider, the important executive power issues. So state of play, he's out of luck. And now, Jack Smith has the information from Twitter. Trump didn't know about it at the time. Jack Smith can now go forward with it. But there's this potential challenge either here or in the future that the four raise. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.